Hi, my name is Emmeline Wilson, and I'll be doing a presentation on the case of the Federal Commissioner of Taxation v. Brand. This case focuses on the allowable deductions available for Australian taxpayers under the Income Tax Assessment Act of 1936, which had been amended in 1997 and subsequently carries the legislation which will be discussed. This presentation is set out to provide a brief understanding of the legislation that was used in order to provide a judgment on this case, and how the judgment that was made has affected the way in which tax practitioners provide legal advice for their clients. As I've previously mentioned, FCT v. Brand is a case that focuses on allowable deductions available for taxpayers. The legislation which provides information regarding deductions is located under Section 8(1) of the Income Tax Assessment Act of 1997. This section defines allowable deductions as deductions from a taxpayer's assessable income for any loss or outgoings to the extent that A. It is incurred in gaining or producing assessable income, or B. It is necessarily incurred in carrying on a business for the purpose of gaining or producing a taxpayer's assessable income. This is important to understand as it links closely with the case of FCT v. Brand. Background of the case. Mr. Brand invested in a proposed prawn farming venture in northern Queensland. This involved entering two agreements: a license agreement dated 4th of June 1987 with North Queensland Industries, which was to provide the ponds and facilities on land it owned and was to subdivide, and an agreement to farm prawns on the same date with General Rural Services, who were prawn farmers that would manage the farm. On making the agreements, Mr. Brand elected to pay $15,000 in respect of a 7-year license for the use of the ponds and facilities constructed by North Queensland Industries, and furthermore $1,000 to stock the pond. This license was not to commence until North Queensland Industries advised that the ponds were ready, which was to be within a year of signing the agreements. In early 1988, North Queensland Industries was wound up and the land and its improvements were sold, and Mr. Brand received no return on his investment. Mr. Brand claimed a deduction of $16,000 in his income tax return in the year ended 30th of June 1988, but this was disallowed in an amended assessment issued by the Commissioner. The issue of the case was whether prepayment was incurred in gaining or producing assessable income, or whether it was incurred too soon. This was due to Mr. Brand voluntarily prepaying for the license fees for the prawn farming, but deferring commencement of income earning potential. Judgment. His Honour found that Mr. Brand's objective in making the prepayments was not to have the benefit of allowable deduction, but to invest his funds in what he regarded as a good commercial investment. His Honour also found that while the payment necessarily preceded the earning of assessable income, the payment was the means of effecting the investment, which was expected to produce assessable income. Although the commencement of producing assessable income was deferred, the prepayment was not. As for being too soon, expenditure imposed did not fall under the legislation of research expenditure or payment for feasibility studies. In fact, the presented case stood in marked contrast. His Honour therefore denied the appeal made by the Commissioner, and Mr. Brand was allowed the deduction. This case has affected the way in which tax practitioners provide advice to their clients, as it would be of extreme importance to provide a better understanding of what constitutes an allowable deduction under Section 8(1). of the tax legislation, as this would stand as the grounds on which a deduction would be accepted or not. In addition, it would be imperative that the time frames for expenditure on investment with the purpose of producing assessable income are incurred within the guidelines of the legislation and are not regarded as being incurred too soon. I have provided references for any further research you may like to conduct. Thank you for listening.